Hi, my name is Cullen, and I'm a personal injury attorney in Winter Park, Florida. Several times a year, we meet with people who have previously had attorneys on their case, and they decide that they'd like to hire us to represent them in their personal injury cases. The Florida Supreme Court, which is the organization that regulates all lawyers in Florida and sets the rules and regulations that we have to follow, the Florida Supreme Court has decided that clients have an absolute right to decide who they want representing them on their cases. If a client is unhappy with his or her lawyer, then the client has an absolute right to discharge that attorney and hire a new one. Now, there may be an issue in a personal injury case about whether the client continues to owe their previous attorney attorney's fees and costs at the end of a case, but that's another topic for another video. If a client decides to make a change before a lawsuit is filed, then it's pretty simple. The client simply lets the previous attorney know that he or she is discharged, and then he signs the appropriate paperwork to hire a new lawyer to represent him on his case. However, if the case is already in litigation, if a lawsuit has been filed, and if the other side has filed an answer, then it becomes a little bit more complicated. So if a lawsuit is pending and a client decides that he or she wants to make a change of attorney, then typically a motion to substitute counsel or motion for substitution of counsel will have to be filed. So if the previous attorney or the original attorney and his client are in agreement that the client can and should hire another lawyer, then usually this motion will be drafted as a joint motion between the old attorney and the new attorneys. However, sometimes everyone can't come to an agreement, and so sometimes an actual motion for substitution of counsel needs to be filed. And that motion is just like any other motion. If you watch our other videos, you know how motions work in general. But it's a motion that will be filed before the court. The previous attorney, the client, and then the proposed new attorney will all come to a hearing, and then the judge will hear arguments from each of them, including the client, about which lawyer should be representing the client. Now, typically, judges are going to give a great amount of deference to the client and the client's decision. However, there may be circumstances where a judge wouldn't give deference. Like, for example, if it was clear that the new attorney just wasn't competent or didn't practice in this area, in this case, it's a very important case, then there might be situations where the judge wouldn't allow a substitution, but almost always a judge is going to allow substitution of counsel. So as it may sound, a motion for substitution of counsel is generally one of the easier motions that we ever have to file. Nevertheless, sometimes it needs to be filed in litigated cases. If you have any questions regarding motions for substitution of counsel or motion practice in general in Florida, please reach out to us. We'd love to answer questions. You can shoot me an email if you have a question. My email address is kcullen@cullen-hemphill.com. You can always call our office at 407-254-4901. Or you can text us at 407-644-4444. In addition, you can find tons of additional information about litigated cases, car accidents, a whole plethora of legal information on our website, and you can also find hundreds of videos on our YouTube channel.